Negligence. This is the tort that most people are familiar with. Car accidents, slip and falls. The Industrial Revolution, which began early in the 19th century, created a series of problems for the law of torts. Railroads, machinery, and new tools were contributing to a growing number of injuries to people and property that did not really fit within the framework of intentional torts because most of the injuries were really unintended. So the legal system was forced to develop a new set of rules to deal with these injuries, and negligence was it. The point is you have to take reasonable care to avoid injuries to others. Failure to exercise the standard of care that a reasonable person would exercise, this results in negligence. It occurs when someone suffers injury because of another's failure to kind of live up to the duty of care that is required. And we're going to talk about this concept of duty of care. It is irrelevant that the tortfeasor intended to bring about the consequences. And so this is what makes it different than an intentional tort. Here, the point is the only thing that's required is that the actor's conduct created a risk of such consequences. There are 4 elements that a plaintiff, the injured party, would have to prove. They would have to prove that some duty existed, that the defendant had to them, duty to them, a breach of that duty, some sort of harm or injury, could be personal, it could be property related, and that breach caused that harm. And there's 2 components to cause. We say that we have to actually have an actual cause and we have to have a proximate or legal cause. And I'm going to break those up. So the first element of negligence is duty. Did the defendant or the tortfeasor owe a duty of care to the plaintiff? If the answer is no, then we don't move through the next elements. But if the answer is yes, then we move along. The duty to exercise a reasonable amount of care in dealing with others is this idea behind duty. The basic idea of negligence is that members of society, we have a duty to conduct our affairs in a way that avoids injuries to others. That's how we should be. How do we know if there is a duty owed? Well, the question actually is usually up to the court, but think about how we live, right? Drivers owe a duty to others on the road. Property owners have a duty to keep their walkways free of debris and snow and ice and things that can make people trip and fall. We have to keep our property safe for folks who come onto our property who deliver the mail, right? In the event that firefighters have to come or the police have to come. We know that business owners have a duty to their patrons. We know that landlords have duties to tenants and that homeowners for certain people who come on their property. Let's talk about trespasser though. If I have someone who is not invited to come onto my property, somebody trespasses, let's say they climb over my fence and they're in my yard and they trip and fall in a hole that I was digging in my garden and break an ankle. Did I have a duty to that person? The answer is no. That person shouldn't have been there to begin with. So, how do we determine when a duty is owed? The courts determine, like I said earlier, whether or not a duty exists. They're going to look at the relationship between the parties. And some of the common relationships, well, contractual relationship, employee, employer, landlord, tenant, business owner, and patron. They'll also look and see if there was a duty imposed by law. Sometimes there is an actual law or statute that states that somebody has a duty to another. Homeowners have a duty, and it's stated in most statutory law to make sure their property is walkways are clear. You have a duty to warn your guests if there's any hazards on your property. If you have a guest that comes over and there's a hole in your garden, you're probably going to say, don't walk over there. There's a hole over there. Or there's a stump you can trip on. Other duties imposed by law include what we say as, or we refer them to as business invitees. When you invite somebody onto your property, a business is inviting patrons to come in to their place. So our business patrons we call them business invitees. We also have licensees, though. It's kind of automatic. It's already a duty that's owed. Mail carriers. Those are folks who come onto your property. They're given a license or permission to come onto the property. We owe them a duty. So if you don't clear your walkway and your stairs leading up to where the mail goes, if it comes right to your house and they slip and fall, that could be a problem. Firefighters, police, people who we anticipate or may have to come onto our properties, and we've given them that license to do so. Trespassers, I already talked about. Trespassers do not have a duty. We do not generally have a duty. There are very minor exceptions to that, and that's really dependent on the state. I believe in New York there's been a law that was passed regarding trespassers. There should be a notification, and we're talking about a large vacant piece of property that wasn't marked with a sign trespassing, and somebody came onto the particular property and was injured, and there was a big case over that, and some of the discussion revolved around posting a sign, but that was unique to New York. Generally, trespassers, there's no duty. The objective standard of conduct. We conduct ourselves like a reasonable person of ordinary prudence in similar circumstances. This is the standard courts are going to review us when we have a duty. So think of it as the hypothetical person who is always thoughtful and careful and never endangers others unreasonably. That's our standard as when we have a duty. And when we have a breach of that duty, it falls below that standard. How, and the question the court will ask is, how would a reasonable person would have acted in the same circumstances? And are you exposing another to some unreasonable risk, foreseeable unreasonable risk of harm? So for example, you run a stop sign, I run a stop sign because I'm changing the dial, the radio station dial, so I'm not paying attention. Do I have a duty? Yes, I'm a driver on the road. I have a duty to other folks who are on the road and possibly crossing the road or going to be in the road. Did I breach the duty? Yeah, because a reasonable prudent person would not be fudging around with the radio. They'd be paying attention to what they're doing, which is driving the car, hence they would have stopped at a stop sign. Don enters Select Foods, which is a supermarket. One of the employees has just finished cleaning the floor, but there is no sign warning that the floor is wet, and Don slips on the wet floor and sustains injuries as a result. Do we have a duty? Yes, there's a duty to patrons, duty to warn of potential injuries. Is there a breach? Yeah, it fell below their standard. A reasonable, prudent person would have put a sign out there. So, failed to exercise reasonable care, protecting the store's customers against that risk. That risk was foreseeable, slipping and falling. And I will note that a store also has a duty, landowners too, home and landowners too, to discover and remove hidden defects that might injure a customer or an invitee. So, there's a duty to inspect and remove any of the hidden defects. So a store is remodeling and retiling the floor. Down on aisle 1, tiles have been removed, which causes an inch gap, about 2 by 2 feet. The workers cover it up and they use a rug and mat, and then they go to lunch. And you stroll down the aisle looking for a product and you trip and fall, break an ankle. Was there a duty? Yes, there was a duty to discover and remove any of these hidden defects. They hid a defect when they covered it up with a rug. Is there a breach? Yes, a reasonable, prudent person would not have done that. And was there a risk here, a risk of injury? Sure. Could we foresee that happening? Yes, we could. I am on my lunch hour. I'm in a rush, but I need pickles for an after-work office party. I run into the grocery store, find the pickle aisle. As I grab a jar off the shelf, I accidentally knock a jar off the shelf and it falls onto the floor. It shatters, spilling juice and pickles everywhere. But I don't care. I need to get out of there, and it was an accident anyway. I cash out and I don't tell anyone. about the accident. An hour later, you show up and proceed down that aisle. The spill is still there, and you slip and fall despite your attempt to avoid it, and you break your wrist. Can you sue the store? The answer is yes. Was there a duty? Well, you have to say duty. Is there a duty? Yeah, there's a duty here for the store to discover and remove hidden defects that might injure a customer. This is an hour later. It wasn't 2 minutes later. It was an hour later. And we can find that out because, stores have video cameras now. So was there a breach? Yeah, because a reasonable, prudent person would have discovered and would have looked for and discovered defects and removed it. And this created a risk to patrons. If a defendant has guarded against all foreseeable harm and exercised reasonable care, they're not going to be liable. And that's even if a plaintiff is injured. So we have Bob, who is carefully driving his car within the speed limit down a street, and a child darts into his path and is hit and injured. Can Bob be sued? Well, they might try and sue Bob. But if Bob was acting as the reasonable, prudent person would in that situation, like I said, he was carefully driving his car within the speed limit, and something happens, then he's not going to be liable. We have to have a breach of the duty of care, and that duty of care is based on the objective standard. So in this instance, there was a duty, but it wasn't breached. Professionals. Reasonable care. There's a higher level reasonable care of professionals. An individual with knowledge, skill, or intelligence superior to that of an ordinary person has got to conduct themselves, or their conduct has to be consistent with that status. Who are we talking about here? Accountants, lawyers, doctors, architects, psychiatrists, that level of professional, or any sort of, you can say any sort of professional that has a specific high degree of knowledge or skill or intelligence. The individuals that I named off, or the types of professions I named off, those folks are required to carry some level of insurance to help ward off against this, or to help them in the event that they do, their standard does drop below. Malpractice is the word we use for that, for suing doctors, lawyers, accountants, architects, those individuals. But there's still the idea of duty and a breach of that duty. They're just held to a higher level of skill based on what their knowledge, skill, and intelligence is. So this sets up our first two elements, duty and a breach. The next video, we will talk about harm, causation, and finish it out with damages.